transaction gets authenticated on the.
So your voice
All
is
right,
breaking. Can you please a bit louder?
all right, all right.
Sir?
I'm audible, right?
Yes,
Am I
sir.
audible?
Yes, sir.
All right, all right. So this is about the importance of blockchain and cryptocurrency in general. So generally speaking, this is how they derive their value. Now let's move on to the area where we discuss the stakeholders of this industry. So what we call the cryptocurrency industry, there are a lot of stakeholders who are actively associated one way or the other, right? So we have the Bitcoin exchanges, cryptocurrency exchanges. We have service providers who function in giving you wallets. So just like your physical wallets where you store cash, your fiat money, the same way you have wallets for storing Bitcoins, and they can be easily downloadable by way of an open source software, right? You have the regulators, you have the government, and of course you have the individuals who transact on a frequent basis using these Bitcoins. So this much is evident that a lot of stakeholders are actively associated with Bitcoins on a regular basis, and that is why regulating this emerging area of law is a part of what you call technology law, which was not heard of until a few years ago, but now technology law has evolved into a widespread area of practice, and we'll be discussing this shortly. Once we discuss the judgment, will move on to the area of tech law. So the idea is that this is how Bitcoins are gaining their value, and these are the stakeholders. Now, what is important to understand here is when we are talking about Bitcoins can be generally obtained in two methods. So there are basically two ways to obtain a Bitcoin. One is where you can approach a Bitcoin exchange or what you call a virtual currency exchange. These are basically like stock exchanges, except for the fact that stock exchanges facilitate buying and selling of securities, shares, etc. Whereas these virtual currency exchanges, they facilitate the buying and selling of Bitcoins, right? So these are virtual currencies acting as a platform for obtaining, buying, selling, dealing with cryptocurrencies, not just Bitcoins, but any kind of cryptocurrencies. Then we have the second method of ensuring that you get Bitcoins with you, and that is by a process known as virtual currency mining, right? It is known as Bitcoin mining. It can also be termed as virtual currency mining, where what usually happens is you will make sure that there are large infrastructure systems in place, and there are a lot of algorithms that you have to solve. The quicker you solve these algorithms, the more Bitcoins you have with you, right? So these are some of the instances where it is possible for us to obtain Bitcoins. Now we move to the most important part of this webinar, which is discussing the judgment and the implications that we can have that can arise out of this judgment, right? Now, so the name of the case, as all of you will be knowing, is the Internet and Mobile Association of India versus Reserve Bank of India and others. So the case was decided on the 4th of March of 2020. The verdict came out. It's a lengthy judgment. It's a judgment of 180 pages, but I've summarized the judgment for you so that we will be focusing on the brief aspects of the concept of cryptocurrency and how exactly did the Supreme Court decipher that what is the nature of these currencies. So are they commodities, are they securities, or whether or not they are currencies, right? But before we do that, we'll just do a quick recap of exactly how this case materialized, how the case reached the stage that where it is now. So basically what happened was the Reserve Bank of India in the month of April 2018, in the month of April, they came out with an internal communication. They came out with a circular which prohibited banks, financial institutions, virtual currency exchanges to deal with bitcoins or any sort of virtual currencies and providing any sorts of services related to these currencies. So the prohibition was not on trading of bitcoins per se or trading of cryptocurrencies per se, right? The prohibition was on these banks and financial institutions providing Bitcoin or cryptocurrency based services to any individuals or any corporate clients or any of the such stakeholders, right? So this was the circular which led to this dispute.
Sir,
Right.
sir,
Adesha is asking, yeah.
sir, can you mention the name of the case again?
Yes, Atin. Right. The name of the case is Internet and Mobile Association of India versus Reserve Bank of India and others.
All right, sir. Please continue.
All right. So, like I was saying, when we are talking about this judgment, it has important implications in the sense that it is the first historic judgment in the context of the cryptocurrency industry, which clearly talks about the legality of the cryptocurrencies, right? We'll discuss the judgment in a short while. Now, as we were discussing the facts, so the RBI laid down this circular that the banks and financial institutions, virtual currency exchanges are prohibited from dealing with virtual currencies. And the reason they made that possible was they had, even before the 2018 circular, brought out many press releases. So there were a couple of press releases that were issued in 2017. Then there was one press release that was issued in the year 2013, right? And during those press releases, one of the important points that the Reserve Bank harped upon was that such currencies are dangerous. Their value often fluctuates. They are not associated with any central banking authority. And so that is why the Reserve Bank of India, in public interest, cautioned all the people, all the stakeholders, individuals, investors, traders, corporations to refrain from dealing with such currencies, right? But we must understand here the difference between a press release and a circular. When we are talking about a circular, that is an internal communication from the central bank to all the banks on its network. So that has more binding value on the respective stakeholders as opposed to a press release, which is more like a warning. So that is why the Internet and Mobile Association of India, it got worried because of this circular, because this organization is a not-for-profit entity. It represents the digital services business of the country. It represents the cryptocurrency startups, all the blockchain-based startups. It is one forum for representing all these entities. And so that is why, by way of a writ petition, this particular judgment happened. And way back in 2018, when the circular was passed, the IAMAI immediately went and filed this writ petition. Right. Samaira has a question regarding when was the circular passed. The circular was initiated by the RBI from the time of April 2018. April 2018 was the time when this circular was issued by the Reserve Bank of India. Now coming back to the judgment, if you see, the judgment is basically on procedural law, because nowhere in the judgment does the Supreme Court say that the RBI does not have jurisdiction. So basically what the issue was in this case, that it was contended, it was basically argued by the RBI that the IAMAI being a not-for-profit entity, they are representing the interest of virtual currency exchanges. They are saying that this is not currency. So RBI clearly has jurisdiction on the matter, because by virtue of different legislations like the RBI Act, the Banking Regulation Act, and the Payments and Settlement Systems Act. These three legislations combined together was contended by the RBI that it gave jurisdiction to them to issue such a circular. So the issue was mainly regarding whether or not RBI has transgressed its statutory powers. in issuing such a circular. So as you can see, this is a procedural issue. It's not an issue related to substantive law. But nevertheless, it gave the Supreme Court an opportunity to delve into the legality of cryptocurrency, and that is what it exactly did. If you read the entire 180 pages judgment, you'll find out that this cryptocurrency concept, they have clearly delineated the history of the cryptocurrencies, the recent reports of IMF, OECD, Parliament. They have discussed legislations concerning the same subject matter from Germany, UK, Australia, and by relying on all those reports, they have come to the conclusion that cryptocurrency is actually a kind of a currency, except the fact that it is not tangible, but nevertheless, it can be treated as currency under the FEMA Act, that is your Foreign Exchange Management Act. Aten, am I audible?
Yes, sir.
All right.
Yes, sir, I can hear you.
All right. So the Foreign Exchange Management Act, it basically defines the term currency, and the Supreme Court was of the opinion that RBI, even though it had not scientifically arrived to this conclusion that virtual currency can be classified as a regular currency or within the ambit of regular currency, still the Supreme Court said that they can be classified as such currencies. So only one issue was that whether or not the RBI had transgressed its powers. So in dealing with that issue, the petitioners in this case, that is the IAMAI, they had contended that their fundamental rights under Article 19(1)(g), freedom of trade and profession, that was violated. And the RBI had clearly exercised its power beyond its statutory authorities because they were claiming that these are crypto assets and not cryptocurrencies. So if they are assets and not currencies, then they cannot be within the purview of the Reserve Bank of India. And so therefore, RBI has no jurisdiction. So in summation, this is what the contention was from the petitioner's side. And so therefore, they also contended that RBI had acted ultra vires these legislations based on which it was exercising the jurisdiction. Now, speaking from the Reserve Bank of India, they made a lot of good arguments regarding the constitutionality of this circular, where they had stated that since the last 3 to 4 years, in fact, for the last 5 years, they had come up with press releases warning the investors, the individuals in general, and all the stakeholders that such a currency was dangerous to deal with because its value was fluctuating. And so the question of non-application of mind does not arise, because this was one of the contentions raised by the petitioners, that there was non-application of mind. So that did not happen. And if we go through the entire judgment, you'll find that almost for 170 pages, you get the feeling that the Supreme Court is actually in favor of the RBI. It is only when the question of the proportionality comes up, that is when the Supreme Court deviates and takes the stand in favor of the petitioners. So, for instance, the Supreme Court has said that RBI no doubt has broad powers under the Payments and Settlement Systems Act, the Banking Regulation Act, the Reserve Bank of India Act to deal with these things. But the circular that they issued, that demanded a blanket ban on all these cryptocurrencies and not a phase-wise ban. So this circular, according to the Supreme Court, went against the argument of the RBI that they had issued these warnings before, but there was no study put forward by the RBI to show that it can damage the economy significantly, that is the Indian economy. So that is why the Supreme Court said that when we can apply the doctrine of proportionality in this particular case, because that doctrine, it usually applies to cases in administrative law when you involve regulators, when you involve quasi-judicial authorities. So applying that doctrine of proportionality, the Supreme Court said that the RBI circular is not proportionate with the evidence that it has produced on record. So that means it has transgressed its power to a certain extent, and therefore that circular stands to be quashed. So if you can see, the entire judgment rests on a technicality argument. Of course, the Supreme Court found a method to discuss the legality of cryptocurrencies, and if I would mention the relevant page numbers of the judgment from page 66 to 106, these 40 pages of the judgment, they are the most critical part of the judgment because they clearly delineate the nature and characteristics of these commodities as virtual currencies. So there they discuss how such crypto assets can be treated as a commodity, where can it be treated as a security, what does the US Securities and Exchange Commission think of this, what does the IMF think of this, and after making a culmination cumulative analysis of all this, they come to the conclusion that this particular currency, virtual currency, can be called as part of cryptocurrencies. So when we are talking about cryptocurrencies, the main implication of this judgment is it opens the doors for Indian economy in an unprecedented manner. Because now we have a scenario where you can have startup founders, blockchain startups, startups providing wallet services, startups providing cryptocurrency exchange services. All of them are now eligible to get funding because they can rely on this Supreme Court judgment and they can say that the highest court of the country, the apex court of India, has declared RBI circular as unconstitutional on the grounds of violating the doctrine of proportionality. So this is one important. Yeah.
What is blanket ban?
Right. Blanket ban refers to a complete prohibition in all activities that the banks and financial institutions can deal with when we are talking of cryptocurrencies, as opposed to regulation. See, when we are talking about a regulation, then it includes this concept of prohibition. But of course, prohibition means a complete ban, and as opposed to regulation that the petitioners were contending that that should not have been a complete ban. So that is what blanket ban refers to, a complete prohibition on trading or any sort of dealing with these virtual currencies by all the financial institutions, banks.
Yes, sir, please continue.
I hope I've answered the question correctly as well.
Yes, sir.
All right.
So
all
now
right.
you want to questions of
Sure. I can take questions now if anybody has any questions.
Because in 5 minutes this session will end and we have to shift to another link.
Right.
We have one question. But as Supreme Court allowed it, what Supreme Court opinioned about anonymous transactions?
Right. See, anonymity of the transactions is something which is inherent to Bitcoins, because you cannot have a Bitcoin transaction without anonymity. That is the edifice on which the Bitcoin transaction is resting. So if you go through the judgment, there is no such discussion on the anonymity of transactions, because the larger focus is on the discussion about the legality of these cryptocurrencies. The nature of the cryptocurrency, like I discussed in the first few minutes of this webinar, that includes anonymity of transactions. So I don't think that that view can be altered, and that is precisely why the Supreme Court has refrained from delving into that part of the cryptocurrency transactions. So anonymity is inevitable in Bitcoin transactions. It has to be.
So the banks are still prohibited from providing services regarding cryptocurrency.
Could you repeat the question once again?
I'm saying, so the banks are still prohibited from providing services regarding cryptocurrency.
No, the banks are not prohibited anymore. After the 4th of March 2020, that was the date when this judgment was given. After that date, the banks are no longer prohibited because that circular stands to be declared as unconstitutional. So no longer banks, financial institutions, virtual currency exchanges, they are no longer prohibited. So long as RBI does not come up with, let's say, another similar circuit.
Excuse
What
me.
was the article that you stated?
Hello.
Pardon, could you repeat the question?
I'm saying, what were the articles you stated? There was a question from Samira Guledia.
Yeah, if you could provide me a little bit of elaboration on that. By article, what do we mean? What do you mean by article? What sort of article?
Sorry to
All right,
disturb you
sir.
all.
Till then, we'll
Hello.
take another question.
Hello, Atin.
Yeah,
Yeah, we have to
Yeah.
yeah, Devshri.
leave this meeting right now because it's gonna end. So can you guys please shift to the second meeting? Please open the second link we have provided you. Hello.
So we are ending this session.
All right. All right. All right.
We'll start with next link.
So
Okay.
Click the
everybody
next
leave
link.
this meeting and
Okay.
open the second link.
So
I'm just starting it.
Yeah. Yeah. Please.